welcome to today's HIPAA Chat. I'm Carol Flagg of Answers Media Network and Healthcare Now Radio. Thanks for joining in. If you are a repeat HIPAA Chat attendee, thanks for taking your time today in August. You know the drill. We talk about the latest news, things going on in the HIPAA industry, what you should be doing, what you should not be doing, and then we open it up for Q&A with our moderator, David Healthcare. If you are new to HIPAA Chat, though, hopefully you'll find this experience worthwhile. Again, we'll spend about a half hour talking about the topics and then start taking questions. You can use the question toolbox found on the dashboard of GoToWebinar. HIPAA Chat would not be possible without our sponsor, eFax Corporate. We surely appreciate all the time and attention they've given to us over the last several years. As of December 31st, 2017, eFax Corporate, which is a division under J2, had achieved 22 consecutive fiscal years of revenue growth. You can check out their suite of secure transmission products at enterprise.efax.com. About us, obviously, this is Answers Media Network. Obviously, we publish a series of topic-driven websites in the healthcare delivery and health IT space. And we also, of course, run our internet radio station, Healthcare Now Radio, which is streaming 24/7, Health IT Talk 24/7, 7 days a week. We currently live stream to over 1,000 US listeners a day, 1,400 worldwide. Obviously, you can stream it live at that link, Healthcare Now, https://healthcarenowradio.airtime.pro. We hope you start tuning in. David Harlow. David Harlow is our host of HIPAA Chat, and we are thankful to have him back once again. He's a healthcare lawyer, consultant, and award-winning blogger with over 25 years of public and private sector experience. His focus, of course, is on digital health law, policy, and all things related to HIPAA, and he works with covered entities, business associates, big data analytic companies, developers, and more. David also hosts a radio show on our radio station, Healthcare Now Radio, called Harlow on Healthcare. And you can tune in weekdays at 4:30 Eastern to stream his latest episode. And you can go to our SoundCloud channel, Google on SoundCloud, just search on Healthcare Now Radio, and you can hear his on-demand podcasts of previous episodes. Read his blog, please read his blog. It's incredibly important. It's www.healthblog.com. Contact him at david@harlowgroup.net. Follow him on Twitter, of course, at healthblog, and at Harlow on HC, which is short for Harlow on Healthcare, his radio show with us. If you'd like to check out past HIPAA Chat events, you can go to YouTube and search on HIPAA Chat or Answers Media Network or High Tech Answers, and you'll find them somewhere. Please check out our podcasts of previous episodes, like I said, on soundcloud.com/HCN radio, and then you can see HIPAA Chat. And then, of course, you can follow us on LinkedIn. We have a HIPAA Chat group where we actually post discussions and whatnot, so we're there as well. So, David, we've had a busy summer news-wise. I mean, summer's been slow for a lot of people. We are, I guess, in the official dog days of August, although with kids going back to school as early as they do these days, I don't know if that's true anymore. But it's been a busy month or two since our last HIPAA Chat.
Yes, it absolutely has. And there's some news that I wanted to discuss with you, and also just wanted to throw in a general overarching good housekeeping kind of observation and recommendation to kick us off today. And that's the question of controlling role-based access as a strategy to mitigate risk. We hear about so many individual cases, complaints, whether they're state cases, federal cases, OCR, Office of Civil Rights investigations, other things. The bottom line, and everyone who's listened before has heard me say this before, that our fundamental issue boils down to human factors. And the more we can do to offload decision-making from individual human beings, meaning narrow the field of their choices where appropriate, the better we can be, the more secure we can be, the more private health data can be. So many organizations have access to PHI set as either on or off. If you're a clinical person, you will have access to PHI. If you are not, with certain exceptions, you will not. And the question is that really the best way to go? And my answer today is no. For many organizations, just shooting from the hip today, Carol, and just give you a straight answer. You think it's a good idea? The answer is no.
No, never.
We really
Okay.
need to have role-based access. And while sometimes you'll get pushback from individual clinicians saying, it doesn't matter to me if I am a neurologist and somebody has been admitted for an orthopedic issue. I need full access to all of that orthopedic episode for my neurology patient, and maybe that is appropriate, and that should be sussed out in detail in discussion. And I'm not here to say that no one should have access to anything that he or she is not involved in directly. We all often need information that goes beyond our own direct experience in order to do our jobs. I understand that. But there is a limit. We need to determine those limits and set those limits for individual types of employees. So it's not just about clinical employees in a clinical setting. It's not just about administrative employees in a clinical setting. It's also support personnel, others who are involved with PHI at a business associate level. We need to make sure that not all members of a business associate's workforce have the same level of access to PHI if they don't really need it to execute their functions. So as I said, many problems with breaches can be traced to staff, and many of those problems can be avoided if access is controlled more tightly. Of course, there are other issues at play as well, including training and follow-up and testing and so forth, but a fundamental first step is to decide, does this person really need access to all of the stuff that he or she has access to? And again, often the answer is no. And it makes sense to just sort of limit access in order to limit exposure. It's all about limiting the surface area of the potential attack.
Yeah. The beauty, of course, is in the digital electronic world, that is easy to do. I mean, back in the days, I guess, where everything was paper, obviously a patient's file folder included everything, right? You know, it just did, right? One file folder per patient. And so now, of course, the electronic world allows us to control who sees what in that virtual folder now.
Right, and it just makes sense to do that intelligently in a context-sensitive way. This is not a one-size-fits-all kind of approach, but for many organizations, it would make sense to take a cold, hard look at this. So that's my challenge to you, listeners, is this is your back to school challenge for the fall. Think about, is there a way that you can reduce the surface area that is exposed to the risk of breach by limiting the type of information that is available to each member of your workforce?
Yeah, it's great advice, as always. All righty. This was big news.
So this is big news for a number of reasons. So number one, it's a large provider. It's a name we've all heard of, MD Anderson, and it is a large dollar figure settlement, ruling in favor of OCR in the case of a breach that happened at MD Anderson. And the question is, why this much money? What happened here? How can I be sure that this doesn't happen to me, right? The key issues here, I think, are the size of the organization, because the size of the breach wasn't that great in the scheme of things. We're talking about 30,000 records. I mean, it sounds like a lot, but
Right.
we've seen laptops stolen that have over 1 million records on them. It's an unencrypted laptop that was stolen from an employee's home. There was also a USB drive that was stolen with a smaller number of records. But the point is that these breaches happened, I think, on the order of 5 or 6 years ago. We're just hearing about this now. This is just sort of coming to its conclusion now. But the point is that folks at MD Anderson acknowledged throughout the process of the investigation that, yes, we had been thinking about encryption and what we needed to do about encryption, but they never actually did anything about it. And so the fact is that they were thinking about it. They should have done something about it, not just think about it, not just talk about it. And in this day and age, even though encryption is not quote unquote required under HIPAA, it is required under many, if not most, if not all state laws. And frankly, encryption is all but required under HIPAA. I think it's sort of a misnomer to say, oh, it's not really required under HIPAA. It's required under HIPAA unless you have a really good reason why you're not encrypting data. Okay, so it is possible to be HIPAA compliant without full encryption in place, but there needs to be a reason why that information is not being encrypted. And I can't for the life of me think about what the reason would be for a laptop with PHI in an employee's home not be encrypted. No good reason for that.
Yeah. So it wasn't so much the size of the number, like you said, million. I mean, we're going to be talking about LabCorp here in a second, but it wasn't so much the size of the records breach, but it was with sort of, I don't want to say negligence, but it seems like something, egregious on the part of MD Anderson, where they were like, oh, we're thinking about this, but we never got around to doing it.
Yeah, exactly. Sort of at this moment in time, we've all seen enough of these cases. We've read enough of these cases to know that, yeah, encryption is a pretty serious thing that you really ought to be doing. And had the laptop and the USB drive been stolen, and if they were encrypted, this would not be a breach. Period.
Right. Period.
So
Right.
that's a tremendous liability that could have been avoided. And was the data on the laptop or on the USB drive actually accessed and used for some illegitimate purpose? Chances are no, that this is just computer hardware that was swiped and sold, fenced to somebody so that somebody could get some cash for a computer that they stole. This is not a focused theft of medical data, but in this circumstance, it needs to be treated as a breach. So why not just encrypt? It's a relatively straightforward thing to do in this day and age, and it would just save you that hassle, that headache, and that money.
Yeah. And like you said, MD, I mean, everybody knows who MD Anderson is. There are, of course, these hospitals and research centers that have recognition across the US and even worldwide. So, it perhaps, I'm not saying that was part of the fine, but I think that the idea being that even MD Anderson didn't take this to the level that they should have. And they're MD Anderson, you would think, right?
Right. And there's this sort of general belief, and I will admit to feeding into this, and I think there's an element of truth here.
I know what you're going to say.
Breaches are kind of inevitable. I mean, the
Yeah.
breaches are inevitable. I mean,
Yeah.
what is privacy? What is security? Is there such a thing anymore? What
Mm.
can we do? So the point here is you don't just throw up your hands and say, well, we can't stop this because half of the US population or more has been hacked.
Sure.
And what can we do? It's over. Well, it's not over because there are individual bits of information that each of us are holding, and we need to hold them securely, or else we're exposed to this kind of liability. That's the lesson here.
Yeah, I was reading recently that since the last 15 years, 2003, OCR has issued over $80 million in fines. And I bet if you, I'm not saying 100% sure, but I bet if you plotted that on a graph, I would say, I bet the bulk of those, that 80 million in fines has just been in the last, 3 to 5 years.
Yeah, I mean, certainly it's been the fines have been getting heavier as
Yeah,
time goes on. As is often the case with the adoption of a new regulatory scheme, regulators sort of give people a free pass for a little while.
yeah,
Make sure you sort of know what you're up against, know what you're doing, understand what the rules are. And even at this point, from the regulator's perspective, they do not view a $4 million fine against an institution such as MD Anderson as a catastrophic level fine. I mean, I don't know what the
right.
annual
It's
budget
true.
is,
Yeah,
but
yeah,
it's a lot of money, but it's not as much money for MD Anderson as it would be obviously for a 20-person multi-specialty practice, for example.
right.
The point is to send a message.
And they did. Let's see here. This again was big news and has been big news over the last 3 to 4 weeks. Um, the LabCorp breach.
Yeah, so LabCorp. So this is troubling on a number of levels. I'm not going to
Mm,
necessarily point a finger at LabCorp because we all know that ransomware attacks are difficult to protect against. There's certainly a lot of things that you can do, and I'm sure there are plenty of things that they did do, and all the facts are not out. They put out some information because they're a public company and they had to disclose some stuff, but of course they're not disclosing everything at this point. They stated that it was a ransomware infection. They identified the ransomware package. It's called SamSam. And the thing that we need to think about here is that even a large organization like LabCorp, even a large organization like MD Anderson, these organizations are still having trouble plugging all the holes. And it requires a higher level of effort than most organizations have been devoting to cybersecurity. When people talk about sort of percentage of IT spend that needs to be devoted to cybersecurity, most organizations are underspending by a significant percentage versus what some experts, and of course there's a variety of opinions on this. I'm not going to quote a particular percentage, but there is a range that many folks would say, well, this is how much you should be spending on cybersecurity as a percentage of your IT. And most healthcare organizations are just not doing that. So there's a certain fatalism that exists. And as a result, we continue to have these large breaches. Again, I don't know what might have been done that would have prevented this or if it could have been prevented, but that is a significant issue overall. The other issue to consider in the LabCorp case is that this is entree into potentially thousands and thousands of other systems. I mean, lab
right,
test
right,
results
right.
are sort of one of the highest volume data items in healthcare. I think LabCorp does something on the order of 2.5 million tests per week, if I'm
Right.
not mistaken.
It's a huge number. Yeah.
So it's just enormous. It's going out to from hundreds or thousands of lab sites to thousands and thousands of physician offices, hospitals, others, and each point where this LabCorp data touches is now potentially infected by this ransomware. So LabCorp did the smart thing and basically shut down their system. So that's a temporary inconvenience, of course, in terms of not getting lab results when you expect to get them when you're trying to log into a portal and the portal is down, or not having results pushed to your EHR or through an app or however else they do it. But they did not want to risk, once they realized what was going on, the infection to so many other systems throughout the healthcare universe. So that's the thing you have to do sometimes. It's disruptive, but it's the right thing to do. Did it stop this ransomware infection in its tracks? We don't know. One of the issues around tracking ransomware is that many organizations are not prepared to say that they have been attacked. They don't want to admit it. There's been some back and forth about whether a ransomware attack is a breach and whether it is reportable. But let's say that it is reportable. So healthcare organizations that are covered entities or business associates ought to be reporting that. I think there's, at least an open question sort of philosophically about whether that should be the case, but let's just say that it is, because that's the position of the government. So there are reports, or there should be reports, that lets people know that they need to take action, patching their software. This is the kind of thing that is often preventable by patching, not always, but sometimes. And there have been cases in the past where folks simply did not patch their software. There were known vulnerabilities and things were not patched, and hacking occurred. Equifax is
Yeah,
one
yeah, I was just
of
about to
those
say.
examples, right?
Yeah,
And
yeah,
on an enormous scale, and sort of hard to believe that that was something that could have been avoided. But that's that. There you have it. And who knows whether this is in the same category or whether the SamSam ransomware was something so novel and new that there was no knowledge that could have prevented the attack. This ties in back to the question of access. It's hard to think about how one might limit access to the LabCorp computer system overall, because there's so many tentacles going in so many different directions and so many people do need access. But part of the issue with ransomware is if you have a limited number of people with access to a system and you can train them and update that training regularly so that people are assured that they will be able to recognize a potential ransomware attack before they click on that thing that infects their computer, then we save the computer from that attack, from that infection. So limiting access, increasing education, ensuring patching, all of these are different elements of the ongoing process that we need to engage in, and the high level of preparedness that we need to have because these attacks are happening all the time.
yeah. And everything I've read about it, it seems to LabCorp's credit, they responded very quickly and announced very quickly, unlike Equifax, where it was many months before they made the announcement about the breach and the level of the breach.
Yes, so that's encouraging.
Yeah.
And again, it'll be interesting to see what exactly happened
Yeah.
there and what the fallout will be.
Yeah. So we've got one more talking point before we start taking questions from the audience, and criminal liability.
Yeah, every
Yeah.
once in a while, criminal
Yeah.
liability under HIPAA rears its ugly head. And this month, it's in the case of an individual in Western Massachusetts who had, for whatever reasons, decided to share PHI with a pharma sales rep inappropriately. And what was worse, once an investigation of this started, this clinician lied to federal investigators about it. And the potential criminal fines and prison terms for lying to the FBI or whatever is worse than the HIPAA exposure.
Right, right.
So the problem is once you get into something like this, you need to think about how you get out of it rather than digging yourself in deeper. It's painful to come clean in these situations, but that is often the best advice. First advice, you know, sort of my professional disability requires me to tell you, you should call a lawyer. You should call a lawyer who
Yes,
knows how
yes.
to deal with this
Step
particular
one.
kind of thing. Okay. Uh,
Yeah,
and you
yeah.
don't talk to an FBI agent before you do that.
Mm,
So that's a problem. Again, obviously, one should not be trafficking in PHI with pharma sales reps without full patient consent and release. But again, you know, if you've gone down that path, you need to think about how to come clean and how to work with enforcement to fix the problem rather than making it worse for yourself.
yeah. And as history has taught us, many times it is the cover up that is the real crime rather than the crime itself. Yeah. All
Right,
righty.
right. And, you know, lying is a lot easier to prove sometimes than some of
Yes.
these underlying issues.
Right. All right, so we're going to start taking questions from the audience. And if we don't get to your question today, you can obviously reach out and contact David at his email, david@harlowgroup.net, read his blog, and of course, you can check out our various podcasts. All right, so question number one, role-based access. That was obviously front and center today. How do you best prevent over access? And what do you do when abuse is occurred as far as further prevention? What advice do you have?
So it's not just a set it and forget it kind of thing. As I
Mm,
hope I've made clear today and on other HIPAA chats, this is an ongoing process. HIPAA compliance is not something that happens one day and then you're all set. It's a constant process. So you can set somebody's access rights, then you need to monitor what they're doing, right? You need to, or even before you set the rights, if someone has broad access rights and you don't feel comfortable limiting those rights, you need to be reviewing what is it that person X is actually looking at on a regular basis. We were just talking about criminal liability. There's another criminal case a year or so ago of someone who just for fun was reviewing medical records of people on staff and celebrities who had come into the
Oh, I remember
facility.
that. Right, right.
Um, you know,
Mm.
that could have been nipped in the bud if someone had been monitoring access on a regular basis. Doesn't mean you need to monitor everything all the time, although maybe there's ways that you can do that depending on the size of your organization and have sort of a rules-based automatic audit going on in the background. But you can also just do a spot check once in a while and get a sense of what's going on. Failing to do that at this stage of the game is really something that you can't do. I mean, you need to be monitoring what people are doing. You need to be self-auditing on a regular basis in order to be able to demonstrate that you are credibly in compliance with HIPAA.
Yep. So a lot of the stuff that we talk about obviously has to do with the penalty funds and the settlements by OCR. Where do these penalty funds that you're talking about end up once recouped? And that actually leads back to the conversation that we actually had in the last HIPAA chat about this idea of some of these funds being split up amongst I don't know if breachees is the correct word, but the victims of the breach, right?
Right, victims. Depending on the context, sometimes funds go to whoever has dropped a dime, okay? But basically the funds are distributed between the OCR, so that gets to fund further enforcement actions. And OCR views their mission more as educational than punitive, right? So they're
Right.
interested in bringing these cases not to hurt the provider community, but to more broadly educate folks about what really should be done in order to protect the patient community. The effect from the fined provider's perspective may be
A little
difficult
different.
to discern, but that's the idea. That's the pitch. Now, as you mentioned, Carol, there's a section of the High Tech Act that calls for the agency to think about how some of these fine dollars can be distributed to victims of breaches, and that's sort of a work in progress. We haven't heard anything definitive yet from the agency about how that might be divided up. And of
Yeah.
course, there are always state actions, and depending on the state, the potential for private actions around privacy and security breaches, not based on HIPAA, because there's no private right of action under HIPAA, but under some analogous state law.
Right. Right. Related to the LabCorp breach, just thinking about what the outcome of this might be, do you think it will impact the future of contracts with medical practices, with labs?
So the question is really, does this help move the needle in terms of where the negotiability of these agreements may lie? Is LabCorp or organizations of that size and bargaining power likely to include anything that is more protective of an individual practice than they have included in their contract boilerplate to date? I don't know if that really moves the needle.
Mm-hmm.
And from a practices perspective, there are two issues. Has the data of an individual patient been breached as a result of this LabCorp problem? And more broadly, has the practices system been infected? And has that made possible or effected a breach of all of its patients' data, not just the lab result of the individual who had a lab sent to LabCorp? So there are a whole host of issues around software that might come up, that might have to come up. But as a practical matter, the most likely current scenario is that there's a relatively one-sided agreement that's presented by LabCorp for signature by an individual practice. Unless you're talking about a large organization, this is not the kind of thing that's usually negotiated.
Right.
And that's going to sort of disclaim much liability for these sorts of things unless they're going to be directly tied to some failure on the part of LabCorp. Now, they're not admitting that they've done anything wrong in their SEC filing. They've just sort of identified the fact that this happened. So they're sort of identifying that so that that basic quantum of information is out in the public domain. There was a ransomware attack, but not more than that.
Right. A couple questions related to encryption. Obviously, we've been talking about that. How do we keep encryption down, and how do we possibly encrypt cell phone text, appointment reminders, and whatnot? I think this is obviously a software issue.
Sure. Well, there are a lot of tools available out there that are encrypted, that are
Yeah.
HIPAA compliant, that can be used for appointment reminders, for patient texting, and other similar uses. And many organizations are already using those on a regular basis because it is really, for the most part, that kind of communication may be easily encrypted, and given the potential consequences if it's not encrypted, again, there's a sort of a high bar to be met in terms of thinking, why should I not be encrypting this? And you would need to document that. And even if you did, you might not be able to get around a state law requirement on encryption. So the tools are out there. Is it clunkier than just plain old vanilla email or texting? Possibly, although some of the interfaces are pretty good, and the risk of not using them is significant enough to warrant using them.
Right, right. Uh, what is the impact on this with medical devices? Encryption, how do we deal with that? Somebody chatted in that accurate device inventory can be a problem.
Well, I mean, we've all heard that Dick Cheney had his
Yeah, yep,
implantable cardiac
yep,
defibrillator, wireless access deactivated because he was
right,
worried about that, and
right.
that was actually a
That made a lot of
plot
news.
line in a
Yes.
TV show a couple seasons back. But the the truth is that there needs to be sort of, at least thus far, as far as I know, at least, close contact, physical contact or proximity to be able to execute a hack like that. Are there vulnerabilities? Of course, there are vulnerabilities.
Yeah.
Anytime we use any sort of communication, there's a vulnerability to interception or redirection. And the challenge is balancing the risks.
Hmm.
For a medical device, the baseline assumption is that we want it to be as bulletproof as possible, because of the level of risk. Something that's providing a direct medical service, or in the case of an implantable or implanted device, is directly connected to a human body. So we don't want to monkey around with that. The challenge is creating something that is going to be, as I said, bulletproof. We don't know. There's always the next exploit that is identified. Every device and every bit of software that we use in every part of our lives always gets patched and updated because vulnerabilities become known over time. So the challenge is to continually update these things. We've all read articles about systems in whether it's in the financial services sector or in the medical sector, where things are not really updated on a regular basis, and that's really where this tends to fall apart. It's really imperative that firmware and software and everything else gets updated on a regular basis as vulnerabilities are identified. And that's certainly the case in terms of the medical devices and Internet of Things.
Yeah. And this was, of course, part and parcel, as you mentioned earlier, to the Equifax breach, that it was a patch that wasn't software update that wasn't updated. And
Right.
as a consumer, we see this all the time, right, with our devices and our own computers and whatnot. And so it seems sort of nonsensical to me that people wouldn't update their software programs for these patches, but you can kind of see in a
Right.
busy
Yeah.
environment how that could happen.
Mhm. Yeah. Again, as I said before, it really requires a financial investment at a level that most organizations are not prepared to make. That's
Yeah,
really the fundamental issue.
yeah,
It
yeah,
costs more money. And part of, one side of our brain is saying, well, I thought computers were supposed to save time and money, but look, it just makes everything more complicated. I think
right.
if you step back a little bit, hopefully we see that there's improvement on a broad scale, but certainly at the close up, right in front of our faces perspective, yes, there are additional costs that we need to incur in order to maintain the security of these devices and programs.
Yeah. One of the attendees chatted in, I did not know this, that Medtronic was recently cited as a device maker whose devices were easily hacked. I had not seen that up there.
Yeah. Now, I mean, some of these things are hacked for good, right?
Oh,
The
yeah.
the closed loop artificial pancreas self, maker crowd, patients who have decided that, as they say, their hashtag is "We are not waiting," and they took older insulin pumps that were hackable and basically to get, we're able to cobble together continuous glucose monitors and insulin pumps and Raspberry Pis, little handheld
Hmm.
computers, in order to really create an artificial pancreas before it became available commercially.
Oh,
So
wow.
there are ways in which these things can be done for good, of course. I mean, hacking is not always, quote unquote, a bad thing,
Right.
but we do need to make sure that for most circumstances, everything is patched, everything is taken care of, and everything is secured, because we don't want, as our listener mentioned, we don't want a Medtronic device to be hackable in the wild, so to speak.
Right. Right. What is needed for medical malpractice provide insurance that would cover HIPAA breaches or EHR issues or any of the other things we were talking about today?
Well, there's a separate kind of insurance coverage called cyber liability coverage, and that is something that I recommend that everybody investigate, because if you want to have some coverage for these sorts of liabilities, not only do you need to have a data protection program in place with appropriate policies and procedures, you also need to have appropriate insurance in place, as you would for any other sort of risk.
Right. Right. Um, so what are you seeing as the most prevalent HIPAA violation resulting in fines or punishment so far this year in 2018? Hmm.
So it is, I think, in terms of total number of records breached, it's really sort of a network access issue. And that can be some sort of hacking. It could be through some, human engineering, getting somebody's password, getting something onto your laptop and then key logging a password, sealing a password that way, or through some other method. Just in terms of numbers, the only way to get high numbers is through some sort of computer network, right?
Right, right, right.
There were one or two breaches that were surprisingly high in number that were paper records, but that's sort of a blip from my perspective. It's really about getting through a security layer, either by some sort of hack of an individual and sort of gaining access to their credentials somehow, or hacking some vulnerability in the system.
Right. And like you said, the sort of the scalability that you related to a network, right? And the larger the network, it just grows exponentially out there, like you said, the LabCorp. So, um, patients patients send me questions via email. What is my liability if the person sending me the email is not really the patient? Hmm. Somebody masquerading as a patient, or right?
Well, there's sort of a couple of issues, but I'll assume that we're talking about a family member who is communicating on behalf of the patient, right?
Well, see, I went to the
Uh,
dark side, David, like that. I went to I went
okay,
to
well let's look at both.
I read
Let's
too
look
many
at both.
I read too many spy novels. It's just
Yeah. So let's start with the dark side then, Carol. If you want to assume that we're living on the dark side here, then the response is simply, I don't do email. And the only way to communicate electronically is through a secure patient portal. And
Right,
messages
right.
go into the portal, come out of the portal. The only thing that ends up in the patient email is basically you've got mail message, and that
Mhm.
requires that the individual patient, using the individual email address that's been registered, logs into the portal, and to get those credentials, that patient had to be verified, et cetera, et cetera. So that's the way you deal with that. If you have a sunnier view of humanity, then you can use email for communication with patients. HIPAA is supposed to protect patients' privacy and security. So if a patient says, please email me on my regular email, I don't want to have to log into that darn portal again. I never remember the password. I have to reset the password every time. It takes me 20 minutes just to pick up the response to the email that you were kind enough to send. So if you're in that zone, then it's okay to respond by email as long as your patients have opted in to that mode of communication, and they've opted in after you're disclosing to them the inherent insecurity of that mode of communication.
Yeah.
Now, we all have family members who don't do email, whether because of their age or other reasons, and other members of our family communicate on their behalf with their clinicians. And that's okay too, as long as it is consented to by the patient. And from a provider perspective, as long as the family member has been present in a clinical setting with the physician and the patient clearly consents to that person being there and being part of the conversation. There doesn't need to be something written and signed by the patient, though of course that helps and that's a good thing to have around. But the very fact that that family member or close friend has been involved in the clinical dialogue and the patient did not object to it and didn't say, oh, go wait for me in the waiting room, I have to talk to my doctor, that's consent by the patient. So that is sufficient. Whether somebody is impersonating somebody else, that's sort of harder to suss out. And for that reason, many providers will insist on using a secure portal for communications versus email.
Right. Somebody chatted in. I listened to an OCR HIPAA webinar that if a patient insists that the doctor email their PHI via email, as long as the doctor lets the patient know it is an insecure mode, if the patient replies that it's okay, then it's okay for the doctor to do it. You know, the patient says, you know, just email me the vanilla, right? Don't
Right,
put me.
absolutely. Yeah, it's up to the patient.
No.
It's up to the
Uh,
patient. The same may be said for texting in some circumstances. You know, in this day and age, almost everybody has a smartphone, which has sort of more secure communication possibilities. But some people are still working with what we call feature phones and plain vanilla SMS texting,
mm,
and that's okay too, as long as there's patient consent and understanding and acknowledgement that this is sort of inherently insecure. But getting a message across is better than not getting a message across.
right, right. And the provider has the patient presumably sign some sort of document that they've agreed to.
Yes.
Yeah, right. That's yeah. Does a password protected file meet encryption standards for sending patients PHI via email?
Well, password protection is not encryption.
Right, 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 right.
So
True.
no.
Yeah, the answer is no. Right. What do you think? This is I like questions like these. What do you
Well,
think the next?
let me,
Oh, go ahead,
as
sir. Go
opposed to
ahead.
just being, as opposed to just being snippy, let me just say that there are ways that you can deal with that. If you want to make a
Yeah.
file
Right.
available to a patient and you don't
Right.
want to install some massive healthcare IT system, there
Right.
are online file storage services that are available to, the general public. But if you buy the quote unquote professional version and you sign a business associate agreement with the company, and I'm thinking, generically, I'm not making a recommendation, but like Box or Dropbox or one of those, they sign business associate agreements,
Right.
and then that the data is encrypted in the cloud, and you can provide a password to a file to a patient, and then they can access that information.
Yeah.
Now, we end up with the same problem of, well, how are you providing them the password? Is it verbally by phone? Are you texting it to them? Is it like a clear text of a password? Then the whole encryption idea sort of falls apart there. But you can provide information to someone through tools that don't necessarily require a large scale health IT install.
Yeah, yeah. And this is, just obviously in the retail sector, this is, ubiquitous. If you've bought a home, or you're reading a secure message from somebody at your bank or financial institution, your login and password is that to your account, but the email will say, sign in to view your secure message versus it, just being readily available right there
Right,
in the actual
right.
email itself, right? Right. So what do you think the next big HIPAA trend is? I'm not sure if that question is related to, is there anything beyond the, ransomware, cybersecurity, OCR fines? I'm not sure what that means, but what
Well,
could be on the pike? Yeah.
there's a perpetual call by some folks to modernize HIPAA because the world has
Oh,
changed
yeah.
since HIPAA was written and enacted, et cetera, et cetera. And my response to that is generally yes, but. Yes, the world has changed, but HIPAA is an extraordinarily flexible set of standards, just as it is flexible enough to deal with both MD Anderson on the one end and with a solo physician practice on the other hand. It is flexible enough to deal with different levels of development of technology. It's not so tech specific that it needs necessarily to be changed. It incorporates by reference security standards by NIST, National Institute,
Hmm.
that creates these standards, and those can evolve over time, but that doesn't mean that the law or the regs need to change specifically.
Yeah. It got a facelift in 2013 with the omnibus, with you know from that perspective to deal with electronic uh, PHI, um, and then of course there are state issues as well. We're not just sort of talking it on the federal level.
Yes, and of course there are some folks who say, well, we need to go in the direction of the GDPR, have something that's more
Yeah, right. That was a big
more
conversation.
consistent with European rules, et cetera, et
Mhm.
cetera. California actually enacted something that I would call sort of a mini GDPR kind of statute that's potentially much more stringent than other rules in other states, and that may be a default standard that we end up needing to look at over time. I think there are also discussions in Congress about making some changes around the edges, although frankly, Congress is so hobbled at the moment that it's hard to say when or if any significant changes in that department may happen.
Yeah, yeah. And for the benefit of our attendees who may not know what GDPR stands for.
The General Data
Mhm.
Protection Rule, kind of catchy, isn't
It
it?
is, yeah.
That's the EU rule that replaced a previous regime that was found to be inadequate when somebody challenged Facebook's application
Right.
of that rule. The European High Court found that actually their old rules were not good enough.
Yeah, yeah. For those of you out there who got many messages on their favorite websites that that rule had gone into effect, and you actually had to accept that. So it was kind of big. Time for one more question. When evaluating EHR vendors, some have servers located internationally. It's part and point of what we're talking about. Is this okay in accordance with security and privacy standards of HIPAA and high tech?
So the issue of location is not necessarily the key question. If you're dealing with a company that's doing business in the US, then you're going to be able to deal with them in terms of trying to enforce something legally. They're not going to argue with you, oh, you have to sue me in Brazil. You're going to have to, you can deal with them in the courts in the US. So that's usually the first issue that I raise with people who are concerned about dealing with data overseas. The other issue is is there anybody in country overseas who is able to access and download your data. Again, that would be a red flag for me. If there is processing going on overseas and the download and use of data is essentially limited to US personnel, obviously somebody in country is going to have access to the data, but if there is going to be that there need to be sort of tight controls on that. You don't want stuff that's sort of downloaded onto a laptop and goes home with somebody. And of course, a reputable cloud provider would not be
Sure.
doing that. So they're concerned not only about compliance in the case of your account, but for all of their accounts. There would be some tremendous liability there if they were to let that go. So that said, there are ways in which you can have overseas operations, and in fact, some U.S. cloud hosts have backup, mirror servers overseas. It
Mhm.
may make sense to ask that materials be simply kept in multiple time zones across the US, geographically diverse areas, rather than overseas. And sometimes you can arrange for that to happen. Again, depending on the size of your organization and your ability to negotiate these sorts of things. But I wouldn't say that overseas storage is per se problematic.
Right, right. Well, David, believe it or not, another HIPAA chat has come to its conclusion. We're actually going to be back again in September for another HIPAA chat. We have a date to be determined, and we were supposed to have John Lynn with us today, and he was unable to make it. Something came up, so maybe we can twist his virtual arm and have him join us in September.
Absolutely.
Yeah, yeah. Remind everybody that a copy of this recording will be sent out to you in the next 24 hours. David, thanks so much, and we'll see you back on our next HIPAA chat.